Following a hearing ahead of a murder trial for Ashley Benefield, she faces a second-degree murder charge for the death of her husband, Douglas, who was shot to death inside the couple's home in September of 2020. All right, so I got with me Brian Buckmeyer, law and crime legal analyst here in studio. Yay, all right. And we got Katherine Lozado, trial attorney with us. Too bad you can't be here, but it's great to have you on the show. Hi, guys.
Thank you.
All right, so Brian, let me start with you. When I said before the break that I love these kind of things, it's the first thing that jumps out of me as a trial lawyer is on the prosecutor side of things, and we always have these prosecutor defense things. Like, if I were the prosecutor in this courtroom, my blood would be boiling. It is axiomatic. You get that trial order that tells you when your witnesses are due, when your discovery is due, and mistakes like this shouldn't happen because they create those little fissures and fractures in a case that could wind up to be opened by a good defense lawyer to a chasm. And now you also got the judge. You heard him. No, I got a lot to ask the prosecutor. I told you, when I say to you offline, I said it's going to be a bad day for the prosecutor. Talk to me about what your thoughts were on all that.
Well, I mean, I can't sit here and not think about Alec Baldwin's case on Friday, where like a small issue that I was telling people in the morning is like, this isn't that big of a deal. Like, they forgot something. They're going to say they forgot it. They found it. They turned it over at the appropriate time or a little bit late. Judge can give you a slap on the wrist. But to your point, from the defense side, when you manage your case properly, and you make sure your T's are crossed and your I's are dotted, and you hold the prosecution's feet to the fire when it comes to discovery and it comes to evidentiary value of things coming in. When you find these little anthills, you can change them into mountains and make it a very big deal, potentially putting either the judge in a place where they're looking very poorly in the prosecution, which we're starting to see, which is always a good thing. You always want the judge to look at you kindly. It's like having a brother and sister or brother and brother or siblings. Say, hey, mommy and daddy, I'm the good kid. You're the bad kid. You get all the bad stuff. I get all the good stuff. But also, you never know, going back to Alec Baldwin, what small issue may amount to a dismissal. And so I think this is very good for the defense. Like you said, bad day for the prosecutor.
Yeah, let me follow up a little bit about that. The judge's opinion of you is going to make a huge difference in terms of those little breaks you may need. You lose your credibility, you got a problem. But secondarily, kind of getting to Baldwin, and somebody was asking me this question the other day, as a former prosecutor, it is sickening me. That whole case sickened me from the beginning. Charging, uncharging, people prosecuting that weren't allowed to prosecute the case. The whole thing seemed political and stunk to me. But the bottom line is, when prosecutors are sloppy or purposefully, at worst, nefariously withholding evidence, innocent people can be convicted, Brian.
Absolutely. And we made this conversation. I was talking to another host, and they're like, oh, this is like nothing that big of a deal. Like the bullets that were there, they got there eventually, not a big deal. It's like, no. Keeping evidence away from a defense, that's how innocent people go to jail, to your point, and that's not right. To go back to your earlier point about getting the judge on your side, there's always a situation where either one side or the other, you, the prosecutor, makes an objection, and the judge is thinking is like, if they've been giving you the stink eye for most of the trial, they're going to lean in my favor. They say, oh, Bob Bianchi's usually wrong, so it's a 50-50 toss, I would give it up. But if they like me, and I'll make wild objections sometimes, and if the judge likes me, they'll be like, Brian's usually right. And you'll find that you get more objections just by being the more credible person in the room.
Yeah, you just said it, and Katherine, this is exactly like, it's not so much that they like you, but I think Brian is, like Brian's saying, if you are the one who's better prepared, and the judge really isn't sure which side to go on with an objection, the one who seems to be the best prepared, the one who's not been in a credibility issue, if they have to shoot and guess between a 50-50, they're going to go with that person. But I want to follow up on something I think is really important. You can comment on that, but also Daubert. I think this is a really, really important issue, and so our audience understands. The defense lawyer used the term gatekeeper. Judge, you're the gatekeeper. And Daubert is a legal decision followed in virtually all the federal courts and in many of the state courts, which is essentially the gatekeeping function of the court to allow expert testimony in, and that it has to be scientifically reliable. And you heard him, actually, I pulled Daubert up here just so we could talk about it, that the theory has been tested, that there's scientific literature that supports it, that you just can't let people come up and give you an opinion. There's a number of other factors to be an expert to give their opinion, because that's what experts do, unless it meets the Daubert threshold. Can you talk to us a little bit about what happened there in court with regard to the interplay between the defense and prosecution and the judge, and or Daubert? Your choice.
Yes, well, to answer your first question, I agree with Brian. It is definitely about the credibility of the attorneys in the courtroom when it comes to 50-50. And these kind of issues of making sure that you meet deadlines, especially witness disclosures, are the type of procedural issues that keep lawyers awake at night or wake us up at 3 a.m. and thinking, did I file that timely? Because it can have such big ramifications as we saw in the Alec Baldwin trial, the dismissal. So for here, she actually admitted that I thought it was the Kim that was on the witness list. And then I realized on July 12th, last Friday, that it was not Kim, it was a different Kim. Ironically, it's the same day again as Alec Baldwin's case. Maybe that's the day all prosecutors went back to the cases and tried to make sure they crossed all their T's. Because again, credibility is really important when you're in court. It's understated, but always forgotten. In terms of the Daubert hearing, I don't know if I have time to mention that, but I can comment on that next time.
Okay, well, let's get back to that in a minute. I just want to say for all of our true crime aficionados out there, law students, lawyers, learning how to try cases, suggestion from a prosecutorial point of view. You look at your evidence and how you want to present your case and what you want to be saying in summation. You then go back to make sure all your witnesses have been identified, all the discovery has been produced. This is basic prosecutor 101, not to get your pants court with your pants down like this. But I'll get to you on Daubert shortly, but let's get back into court right now and listen to more of this pretrial hearing.
Like she is a new, unexpected witness. I think everyone knew about her all along. And it was an inadvertent mistake that she was not.
But I wouldn't know, putting myself in the shoes of Mr. Taylor, how do I know, is she A, B, or C? So I get these reports, you don't list her, that tells me she doesn't have information related to this matter. You give me these reports, she's not listed as A, B, or C, telling me that, hey, she has information and I can depose her, or no, she's off limits, I can't depose her.
And I would assume that the defense would not know, Judge. But the state is obligated to list every witness that is listed in discovery. So technically, every witness whose name shows up in discovery should be listed in discovery, and her name, by virtue of not being there, is an indication that there was a mistake, because it should have been in there to begin with.
Or she's not relevant, she has no information related to the matter.
Okay. And that may be true. But
I'm just saying, if we're going to make assumptions, there's other assumptions that could fit that scenario.
Yes. As an aside, this witness is available for deposition and can be deposed this week. I just deposed Barbara Russell on Friday. So we are continuing discovery right up until trial. It's not unusual. While I wish this had not happened and I wish I had listed her name earlier, I think it is there is a remedy, and that if the defense would like to depose her, I anticipate her testimony is only going to mirror what is in her reports. So it's no new information. She would not be testifying as an expert. The word expert is next to her name because in our system, typically when she is listed in child abuse cases, when she testifies in child abuse cases, she is an expert forensic interviewer. So she's listed as an expert at the state attorney's office, but she did not conduct a forensic interview in this case. So her testimony would be non-expert testimony, pure factual, based on the information that came in and what transpired after that.
All right. So this is one of those situations where going from practitioner to judge becomes so pronounced. You guys have been living this case for almost 4 years now. So when you tell me it's in her notes, her testimony is going to mirror what's in her reports, that means something to you all. It means zero to me. What is she going to testify about? She's a fact witness. What does she know about the homicide that occurred on whatever day it was, September 27th of 2020? I mean, how is she relevant?
She will testify about the previous reports, how we had
There was a deputy that
Detective
testified.
Moreland testifying about the criminal aspect.
And I
of it.
limited what he could say.
Exactly. And her testimony would be similar, the child protection end of it, but also limited in what she can say. But that would be the information that she would testify about.
Is it the same incidents?
Yes.
Right, because it gets reported, 1-800-96-ABUSE, calls made, it gets routed to CPS or CPT. I still get confused about who's what and who's who.
Right.
Ms. Glenn, I'm just going to do this for real quick, and then we're going to take your plea.
Okay, thank you.
I'm not going to make you wait.
That's no problem.
Thank you.
I got time.
It gets routed there. It may just stay in I say DP world because the dependency cases, right? Maybe it just stays with CPS or MSO, their child protective team. Maybe there's also a criminal investigation, so it could open a CF or an MM case.
Right.
It could also turn into a DP, a dependency case. And then, of course, all of those things could then also be part of a DR case.
Right.
And we have some of that here. I guess my question is, I think I already made the ruling over the defendant's objection that I would allow Detective Moreland to testify at the trial, essentially what I allowed at the stand your ground hearing.
Yes.
And now you're saying, and we want another person to come in and testify about those exact same things.
Judge, it's from a different angle. It is from the child protection team angle, and as Your Honor just said, they're two very different.
All right, listen, I can assure you right now, the prosecutor is shaking in her shoes right now because the way the judge is talking may turn out not to be a great thing. And there's a really nuanced thing that the judge said about being a practitioner and turning into a judge that we'd love to talk about. We're going to do it a little bit later, but we got another fascinating case that we have to cover on the other end of the break. Please stay with us.